Good afternoon. I know quite a few people in here, but for those of you who don't know me, I'm Cathy Cook, and I have my own firm, and I've been practicing for 35 years yesterday, which is kind of neat. And then I started out as a criminal defense lawyer for 16 years, and then I gradually moved into domestic after my son was born and it was time to make real money. So now I pretty much do virtually all domestic unless there's a criminal case that's tied to the domestic case, like I had this morning with a CPO and then a CPO violation that's a criminal case. So I also am gay myself. I have a partner of 25 years and we have a son who's 19. And it's been a long time coming for us to have a legitimization of our relationship, and so Obergefell finally did that for us. And so I have concerns and interest in these issues, and this is the kind of work I do. So, Obergefell, does everybody know about Obergefell? Obergefell changed the landscape. Wasn't really in need of change everywhere, but it was in need of change in 13 states. We are one of them that decided to completely ban same-sex marriage, and our state went even further and banned any kind of domestic partnership that wasn't a legal marriage. So if people didn't want to get married, a man and a woman, and they decided they'd like to have a domestic partnership, which we used to routinely write up documents for that, they couldn't do it in Ohio anymore. So this changed the landscape for both of those. Obergefell dealt with two questions. Does the 14th Amendment require a state to license marriage between two people of the same sex? They answered that yes. And the other one was, does the 14th Amendment require a state to recognize a marriage between two people of the same sex where the marriage was lawfully licensed and performed out of state? That's the crucial question, because there were so many marriages that took place in other states that started allowing marriage, such as Massachusetts, that couldn't be recognized in Ohio. And that created a huge problem in divorce cases, because if you had been married in Massachusetts and you moved to Ohio and you were living in Ohio, you couldn't get divorced in Ohio because we didn't recognize your marriage. But you needed to get divorced because you were legally married in another state. So your options were to go back and meet the residency requirements in that state and then file there, or stay married. Now, some of the states changed that. California changed it before Obergefell to say, okay, we're not going to make you move back here and meet the residency requirements. If you are in a same-sex marriage and you were legally married in California, we will grant you an exemption and you can do the divorce from another state. So that was good. But we don't need that anymore. So Ohio was very quick to respond, which is the good news. Our own probate court, Judge Winkler, was on board completely. He had everything set up so that if the decision came down to ban on same-sex marriage, he was prepared to start marrying people and giving out licenses immediately. And he did that within an hour of the decision. The Probate Court Judges Association then issued a mandate to their judges that they will start giving out licenses, they will start recognizing these marriages. Several of the court judges started marrying people that same day. So they really jumped on the bandwagon. The Board of Professional Conduct, worrying that we might have some judges that weren't in favor of this, issued a mandate, a professional opinion, that judges could not decline to marry same-sex partners. So we didn't end up with any situation like they had in Kentucky with the clerk who refused to give out licenses. So we thought that ended the inquiry, right, about same-sex marriage. Well, it didn't quite do that because some states didn't think they had to do it. So there was another case that ended up in the Supreme Court, and not following completely my outline here, but I'm skipping over a little bit, that dealt with children of same-sex couples. And so in Marissa, if you want to follow this, it's on page 3, in Marissa and Pavin versus Nathaniel Smith, which just came out this summer, the Supreme Court had to tell Arizona, kind of surprised it wasn't Alabama, that they were required, thank you for laughing at my joke, that they were required to recognize married same-sex parents as both equal parents of the children. And they said, when we said it was marriage, we meant it was marriage. It's marriage with all the ramifications of marriage. And if you have children during a marriage, those are your children. So they made it very clear they weren't kidding around in Obergefell, and kids are important. And I just love to quote some of the things that Justice Kennedy said in Obergefell dealing with children, because I think it's just very important. He said, by giving recognition and legal structure to their parents' relationship, marriage allows children to understand the integrity and closeness of their own family and its concord with other families in the community and in their daily lives. Not giving same-sex couples the right stigmatizes children by implying that they are lesser than their peers and they are being brought up by unmarried parents. So the dissent made a big deal out of marriage being for procreation. And Justice Kennedy addressed that as well, and he said, the ability, desire, or promise to procreate is not, and never has been, a prerequisite for a valid marriage in any state, and the constitutional marriage right has many aspects, of which childbearing is only one. So when marriage began, of course, we didn't have all the technological advances of science to do artificial insemination and in vitro and all of those things. So the court was making sure that we weren't sticking to that one issue. Now, there aren't that many unique issues in same-sex divorce, but the ones that there are very important, and you have to really watch it if you get one of these cases. So the first thing is, what if they've had some other relationship that was sanctioned by the state in another state? So you get to the part of my outline on page 1 of civil unions and domestic partnerships. Some states decided, well, we don't want to step on marriage, so we're going to create this new thing called civil unions. And it's like a marriage, but it's not sanctioned as a marriage. So the states that had that were Connecticut, Delaware, New Hampshire, Rhode Island, and Vermont. They all changed civil unions to marriages by statute after Obergefell. So now you have a marriage if you were married in that state, so you can get a divorce in another state. The problem is Ohio doesn't recognize civil unions. So if they didn't convert it, you've got a problem. So the first thing you have to look at when somebody comes to you for a same-sex divorce is, where did you get married? How did you get married? Is it a civil union? If it is, you need to make sure it's one of these states that converted to to marriage, so that they can be divorced. Otherwise, you're going to have to go through a process to terminate the civil union and figure out how to do that in the other state. Now, we still have some civil union states, because not everybody wants to get married. The civil union states today are Colorado, Hawaii, Illinois, and New Jersey. So since we do still have some civil union states where it's not a marriage, again, watch out for that. Because we don't recognize civil unions in the state of Ohio. That may get changed by the legislature, but you know how slowly the legislature moves. We still haven't caught up on juvenile court statutes, which I'll talk about in a minute. Domestic partnerships. Another way that people were able to get a state or city even recognition was with domestic partnerships. Sometimes big cities did domestic partnerships where people could have rights, especially if they were city workers or something, to get the benefit of health insurance, retirement beneficiary, things like that. So we have to watch out for those. 11 states currently still allow domestic partnerships, and I've given you the list of that there. Again, if they come in, find out, did you do a civil union somewhere? Did you do a domestic partnership somewhere? Find out, and if you're doing prenups, ask those questions too, because What if they think I'm not really legally married, I had a domestic partnership? Well, they might have a problem with getting remarried in Ohio. So look into that, and look into some attorney in the state who can help you with that. And since Ohio's domestic partnerships were banned for that period of time that our statute was in place before Obergefell turned it over, we had a lot of predated domestic partnership agreements that presumably were no longer valid. And then we're starting new domestic partnership agreements again. Now those are not considered marriages in Ohio, but you still want to watch out because that could be considered a premarital agreement. If you have a domestic partnership agreement and then they decide to get married but they don't dissolve the domestic partnership agreement, that may control the property and things when they get divorced. So ask those questions. Don't just assume there's no other agreement out there. Do you have something like that? Many people who bought homes together, they wouldn't do a full domestic partnership agreement, but if they bought a home together and if they listened to lawyers and were told, hey, you could end up in a partition action where if you're fighting about who gets the house, took our advice and did joint venture agreements. Joint venture agreements to own the house together, and what would happen if the house, if you got in a situation where they were splitting up and we couldn't decide who was going to get the house. These joint venture agreements would set forth who pays what while we have the house, what happens if we split up, do we just immediately sell the house, does one party get an opportunity to buy the other party out, how do we set the price. I've had many of those joint venture agreements, so just make sure if somebody's going to get married, okay, we're moving to the next step, you look out for those and either terminate them or incorporate them into your prenuptial agreement.
Are there dower problems with the real estate joint venture thing?
They could be. If they get married, there definitely will be. Before they get married, no.
Okay.
But if they've had a marriage somewhere else that wasn't recognized in Ohio, so they did the joint venture, they may have a dower issue if they were married somewhere else. Feel free to ask questions as we go along here. Okay. This is an interesting case. Petty versus Blount Petty. This woman tried to argue that Obergefell didn't set aside domestic partnership, the ban on domestic partnerships. And this was an opposite sex situation. And she argued that the second sentence of our statute, of our amendment, that banned these partnerships, which says, this state and its political subdivisions shall not create or recognize a legal status for relationships of unmarried individuals that intends to approximate the design, qualities, significance, or effect of a marriage. Now, the first sentence specifically banned same-sex marriages. This sentence went on to do this for any partnership. So she tried to argue that that ban was still in place in order to further her cause of her common law marriage. And it didn't work. And the court rejected it. It's an interesting case to read. The next major issue on same-sex divorces is child custody. So, one of the companion cases to Obergefell, that got all the press, but it had a companion case called Henry versus Himes, which was also out of Ohio. And what they did, and I give all the credit in the world to Al Gerhardstein and Jennifer Branch for being very clever about how they did this, so they killed two birds with one stone. They went in and said, okay, we have same-sex mothers who were married legally in other states, and we want both mothers on the birth certificate. And Ohio said, we won't do it. And then they had another plaintiff who was a father, two fathers, one adopted, actually they both adopted legally in New York, and they wouldn't put, they would only put one of the fathers on the birth certificate. So those cases went up with Obergefell, and the court said, you shall put these names on the birth certificates. which they reiterated in the Arizona case, but they apparently didn't think it was clear enough. So all of those people that were plaintiffs in the case got their names put equally on the birth certificates. So now we know, based on the Marissa case that I told you about, that they're going to have to put the names on. But the problem you run into is, what about children born before the marriage? Children in Ohio born before the marriage aren't automatically children of the marriage. A lot of people don't realize this, but if you had children before you got married, let's talk about a heterosexual couple now. You had children before your marriage. You've married for 12 years. You go to court and you say, we have 3 kids. 1 is born before the marriage, 2 were born after the marriage. You put them all on the, do you know that's wrong? Now, if both parties agree, the court will take it. But the truth is, if one party disagreed, all they have to do is say, this child wasn't born issue of the marriage, we go to juvenile court for this child. That's the law. So the same problem exists here. If you have a child born before a legal marriage, or one if you didn't have any marriage, now all marriages are legal. So if you had a marriage in Massachusetts and you had the child after that marriage, now that child, you could put both parents on the birth certificate. But if you have one without that, which I did in 1998, you can't put both parents on there. And we don't have an affidavit of paternity yet, we should have soon, for the second parent to sign and say, I'm a parent. The court hasn't gotten that far yet. The legislature hasn't gotten that far yet. So
how does it affect jurisdiction? Juvenile court versus what?
Well, domestic relations court.
Okay.
So if the child is not of the marriage, domestic relations court legally has no jurisdiction over that child.
Right.
And we call, just to tell you, and I hope my juvenile court magistrate friends don't see this, but juvenile court's the black hole. We call it the black hole because it is a it is a place where you just get mired. It takes 3 months to get a hearing. You just get mired in this process. They haven't totally come into this century yet where they see shared parenting as the real way things should happen, as opposed to mom has total control. You know, by statute in Ohio, mom has custody, but that doesn't mean mom should have forever control when dad files. But we have that problem. So and plus in Hamilton County, where we have this wonderful parenting department, domestic relations court, that can help us with these parenting issues, they don't have that. So you have to hire your own investigator, you have to hire your own people, and it's a nightmare. So believe me, if you can have them part of the divorce, you want them part of the divorce. So what do we do about that? Well, you do a step-parent adoption. So as soon as the parties get married, the non-biological parent needs to do a step-parent adoption. Now, here's an interesting question. So my son lived with me and my partner for his whole life. So if we'd gotten married at the time he was still a minor and Obergefell had been passed, would they make me wait 6 months to see if our marriage was going to last to do a step-parent adoption? I mean, that's the rule. Some counties it's a year. So if they're going to make you wait when you've already had this established relationship, that seems crazy, but we don't know yet what's going to happen, if they're going to require that or not.
In a decree, would you want a disclosure about the 2 different, the premarital child and the 2 marital children? Can you put a disclosure in there?
If you can't say of the marriage. You have to say the truth in your pleading, because we don't want to get in violation of Rule 11.
You put a decree on it, there's no evidence that they disclosed, it was disclosed to the parties.
I'm talking about the complaint now.
Okay.
I don't know. In the decree, they can, as long as the court takes jurisdiction, and you don't even say of the parties in the decree anyway. You just say the parties have these children. So I think you're fine there. I think if you file a pleading and you don't disclose this child was born this date, you know, the date of the marriage, you don't have to say not of the marriage, but you can say this child was born this date, this child was born this date. It's seen who is part of the marriage and not. But if both parents agree, at least in Hamilton County, I can't speak, I haven't had this issue in other counties yet, at least in Hamilton County, if both parents agree to have the child considered part of the divorce case, the court won't fight you on that.
I would think that would be disclosed, or somebody's gonna file something later on down the road and say, hey, you shouldn't have did this, I didn't know about this, or something like that.
Yeah, I think you could, and there are cases out there where the father was deceived. He thought it was his child and it wasn't. And they've come back and said, hey, it was born during the marriage, but that's usually when the child's born during the marriage. Sometimes it's before the marriage. So I'll tell you a sad story right now that I have, a case in Warren County, and it's not on point with this, but it goes to your question. Dad met mom when she was pregnant. They married while she was pregnant, child born during the marriage, so it's presumably his child. They have another child after they've been married for a while. They both know the first child is not his child. We go to file for divorce. He wants to treat that child as his child, so we just filed the date the child was born, which is different than the date of the marriage. We don't say anything about him not being the biological father. We're not obligated to. Mother files her answer, doesn't dispute it. 6 months later, when she gets a bad real estate appraisal that she doesn't like, she files a motion to have him found to be not the father of the child. Just as nasty as she can be. And she's turned this kid's life upside down. And now we're in juvenile court with the bio dad, my client seeking companionship, because the judge said, I'll give him companionship, but when mom brought we thought mom was just going to leave it there, but when she brought the new dad in, by the way, she's trying to get child support all the way back to birth. I mean, how ridiculous.
You could give more support with 2 bites of the apple.
Probably, yeah. So there's all kinds of crazy things that happen about children. So we're going to do a step-parent adoption. That's the key to protecting this. Now, what if your people come to you and they're already contemplating divorce and they never did the step-parent adoption? Well, you have 2 choices. One, you can say, well, how about staying together, getting your step-parent adoption done, then you can get divorced. That's a little, if they know they're going to get divorced, that's not too ethical. So the other option is to do an agreement in the divorce case that gives companionship rights. Now, you can't give parenting rights, but you can give companionship rights. Now, you could also do, the third thing to do, yeah?
Before you move on, I'm not as well versed in family law. Can you just explain the difference between companionship and parenting? Right?
Oh, sure. Companionship is for non-parents. Mm-hmm. So that's grandparents' rights, okay. Siblings' rights, aunts and uncles, even can be strangers, legal strangers, if they have a relationship with the child. The court has the power, in the best interest of the children, to give them companionship rights. They're not a parent, so they don't have parenting rights.
So is that like the right to visitation and stuff like
Yes,
that?
exactly. So when you have grandparents that are estranged from their child, they can file and ask the court to give them parenting rights. Now, that's a whole other topic.
Yeah, we don't have to go into it.
But I'd be happy to talk to you more about that. But that's a whole other topic in itself.
That answered my question.
Okay. So what they could do, and still could do legitimately, is go back to juvenile court and do a shared custody agreement. It's not a shared parenting agreement, it's a shared custody agreement. And believe it or not, the one place Ohio was advanced from most other states was in that arena. And you'll find this information on page 3. And that all started out of Hamilton County again. Thank you, Judge Hendon. In Ray Bonfield. These folks had 6 kids together. They had some biological children. They had some one parent adopted. They had a clan, and they went, while they were still caring about each other, they went to juvenile court and said, we want to have rights to each other's child, legal rights, so that we can, make all the decisions and take care of medical issues and all those things. And the magistrate said no. And Judge Hendon said, I think this is the way it should be. So Judge Hendon awarded it, and it went up the chain and ended up in the Supreme Court. And the Supreme Court said, yes, if both people want to share custody of these children, they can. And it's not just couples. You can do this with a grandparent. I have one where the dad and the grandmother share custody because mom died. You can do this if both parents agree. Now, you know the old saying, bad facts make bad law. Well, see the next case on page 3, Hobbs versus Mullen. Now, I happen to know the people involved in this case. I wasn't involved in it myself, thank goodness. Unfortunately, these folks were together. They planned the child together. But biological mother, even though she gave her partner power of attorney for the child, could, go to school, go to the doctor, all those things, she never would take the next step to do a shared custody agreement. She just never wanted to do it. So when they split up, the non-biological mother filed for shared custody and also companionship rights. Well, read the case. The non-biological mother just did everything in her power to alienate the biological mother. I mean, she did terrible things. She stalked the kid at school. She did crazy, crazy things. And the court said, the mother obviously never intended to give you custodial rights. She never went past a power of attorney. She had all these opportunities to do custodial rights. She chose not to. You're out. So that's not a good case, because you could have situations where the parent and the non-biological parent are at odds, but it's still the best interest of the child for the non-biological parent to be involved. So, bad facts make bad law. Okay, so another question in adoption, step-parent adoption, is what if there's a known father? Sometimes couples use an anonymous donor, and sometimes they decide to have a social father. And so the social father has rights. So if you do a step-parent adoption, that's going to knock the social father out. So how do you handle that in a step-parent adoption? That's an issue we haven't determined yet. Something to think about. Hopefully he will agree to sign away and still be the social father, and I had a case years and years ago with a social father and two mothers, and the social father got a partner, and the partner pushed for him to go for custody, and talk about a quagmire. And the magistrate we had was completely homophobic, and all she did was yell at them for doing this, for having a child in this situation. We ended up going to Judge Hendon, who took the case away from the magistrate and did the right things. But wow. So I don't think that would happen now. Okay.
Did she recuse herself, or Hendon
No.
actively?
The other lawyer and I literally went to Hendon and said, nobody's going to get a fair shake in this, because she thinks what these people did was horrible, and if she had her way, she'd take the child away from all of them.
So did you file a motion to recuse, or what legal action did you file?
No, the judge said, I'll take care of it. So, those were the old days. This was in the 80s, okay? All right. Okay, let's see what else we got here. Okay, here's the next big issue in divorces. When did the marriage start? Okay, this is going to be an interesting question in these cases, and it's already started to be an interesting question in heterosexual cases. I don't know if anybody knows that, but there's a couple cases out there that I'm going to go over that have already started to look at that issue. Now, in 1991, October 10 to be exact, we abolished, by statute, common law marriage. If you had common law marriage prior to 91, you could still have it, you could still keep it, and we do recognize common law marriage if it's done in another state that has different rules. But we don't have it anymore. So, and we don't have palimony, so we don't have anything recognized unless you do these domestic partnership agreements, joint venture agreements, all of that. Pretty easy, right? Well, maybe not. The court is allowed, under the property statute, which I've quoted for you in there, to use the dates it considers equitable to determine marital property. Now, some courts have taken that a long way. So if you look at page 4, the Bryan decision, Bryan is out of the 8th district, and the 8th district is, we are going to recognize these pre-marriage assets. And there's 2 cases cited for you there where they do that. So they're saying, when you show me that parties, in this particular case, Bryan is the classic, de facto marriage date found because they were engaged, they moved in together, they used all of wife's money to pay for the expenses of the household, they saved husband's money, future husband's money, to buy a house. So he's saying, hey, that premarital money in the house that I put down on the house is mine. And the court said, nope, we're recognizing that as marital because you did all this planning to buy it. Those are pretty easy facts. You get into a lot more muddled facts after that. Burek, I can't say this name, the one that follows, that was an interesting case because that was a Muslim marriage gone wrong. They went to New York to get married, and it turned out that the cleric wasn't properly licensed, so their marriage wasn't really real. They both knew it, but they didn't get remarried for 6 years, so the court went back. Those are pretty easy facts too, but that's going to be an issue, especially in the 8th district. Now, the 9th district takes the exact opposite view. We did away with common law marriage. We are not recognizing anything before the ceremonial date of marriage, the licensed ceremonial date. So those are the 2 extremes. What's everybody else going to do? We don't know yet. I have brought this up in Hamilton County to see what the reaction is. They have talked about it, the magistrates, but they haven't settled on anything, and you better bring them some awfully, awfully good evidence before they're going to follow it. So we'll see. But that's something you need to look at for same-sex marriages, because what if we had a ceremonial wedding and we wanted to be married but we couldn't be legally married and we considered ourselves married and we held ourselves out that way? It's a different issue because they couldn't get married. So if you really wanted to be married but you couldn't, heterosexuals didn't have that problem. They could have gotten married and chose not to. Same-sex couples couldn't get married. And what about same-sex couples like me, where I said, what's the point of getting married in Massachusetts when it's not legal in Ohio? And then have potential problems if you want to get divorced. So it's an issue. And we had a meeting in the domestic relations court about this when Obergefell came out, and everybody's arguing about whether we should go back or not, and people are saying, oh, we shouldn't go back. And I raised my hand and I said, wait a minute. Now I realize I'm costing myself a lot of money when I tell you this because my partner's retired. But I think you go all the way back. If you intended to be a couple, if you intended that, and you can show that from both sides, you go all the way back. I think that's the equitable thing to do. We'll see.
What's the third district?
You know, somebody told me there was a 3rd district case, and I threw that in there before I looked, and I couldn't find one. Okay. So honestly, I forgot to take that out. Okay. So, oh, the 2nd district. The 2nd district has weighed in Taylor, which is under the Ward case, and they allowed it. I mean, they didn't allow it, sorry, under the Ward case. So, but they found a common law marriage there, so they got out of it because it was a pre-1991 marriage. Okay. Prenups. I mentioned this earlier. Look at what could there be out there that looks like, smells like a premarital agreement that you need to watch out for. Domestic partnership agreement, joint venture agreement. So just if somebody comes to do a prenup, make sure that's the newest, that's the only thing they're doing. They haven't done anything else in the past. I think that goes for heterosexual couples too. Okay, now I'm going to entertain you a little bit, since we have time, unless anybody has questions. Yes, Mark?
Getting back to the religious liberty, I know Kentucky's brouhaha about the clerk that didn't want to sign it I know working with the Baptist Joint Committee, which is in DC, a lobbying group, was suggesting an alternative, which is to say the court must issue the marriage license. But if this individual, because of religious objections, does not want to issue it, the court could provide an alternate judge to perform the ceremony. So it tries to balance the individual personal convictions of the individual while still requiring the court to honor the law. And I thought that was a fairly nice way to resolve it, but obviously Kentucky went a different way.
Yes, well, I wonder, I always liken that to, would that have been an okay way to deal with mixed race marriages? I mean, you're a public official, you need to do your job.
The
So-
court does its job.
Yeah, you and I can debate that.
Okay.
All right, I'm going to tell you a story that's real, but it's interesting. This is a law school question. This is a case of McKettrick versus McKettrick. 2015 Ohio 366, if you want to read the first decision. 2015 Ohio 366. So, the McKettricks started living together in 1998, and they had a ceremonial wedding marriage in 2000. 2 women. And what happened was, one woman decided to take the name of the other woman, and so they went to probate court and did a name change so that the child they had together would have the same name as both parents. And so they did that first, and after the ceremony, and after the child was born. And they basically, they gave interviews to newspapers about their relationship and their child, and they were, out there as, a family and wanted to be recognized as a family. In 2012, when they split. And in 2013, the non-biological mother filed for divorce. Now, they had already done a shared custody agreement in juvenile court, so they did have shared custody, and they had this ceremonial marriage. Well, in 2006, they did one more thing. They went to Massachusetts, where one of the parties bought a vacation house. And they went to the Massachusetts clerk. Now, at that time, Massachusetts changed this later, but at that time, Massachusetts required you to be a resident of Massachusetts or of a state where same-sex marriage was recognized in order to get a marriage license and be married in Massachusetts. So what did they do? They both went to the clerk and they wrote down the Massachusetts vacation home as their residence. That was not their residence. Their residence was Ohio. They had Ohio driver's licenses. They voted in Ohio. Their main home was in Ohio. But they got married. So when they filed when one of them filed in 2013 for divorce, the other one got an attorney and filed to dismiss. First of all, we're not married because there's a ban on that in Ohio, because Obergefell hadn't come out yet. And second, we aren't legally married because we lied to the court. We lied to the Massachusetts, not the court, but the Massachusetts county. So it was dismissed due to the ban. Went up to the Court of Appeals, they affirm, goes to the Supreme Court, they sit on it because they know Obergefell is under submission to the Supreme Court. So they just sit on it for like a year. And when Obergefell comes out, they just toss it back to the trial court and say, now you do something consistent with Obergefell. Now, I wasn't involved at that point. Unfortunately, one of the party's lawyers died, had a heart attack and died. And I got the call to take his place. So I get involved with the party who doesn't want the marriage recognized. Talk about, having to argue something you don't want to argue. But so we did. And I'm still hanging my hat on the fraud in Massachusetts. And I find an old case in Ohio. So first of all, I had to get a Massachusetts lawyer involved to explain the statutes to me and the changes in the statutes and find me the old statutes. And she actually was a witness. I deposed her to say that if they'd told the court the truth, the county the truth, they wouldn't have issued the license, and it says you have to swear you're a resident of that state or a state where it's allowed. So they both committed fraud, there's no question about it. So I get her to explain the law, and then I go and find this old case where two cousins lied about their relationship and got married, and in those days we didn't allow first cousins to get married. So they committed a fraud and their marriage was null and void. So I tried to argue this to Judge Oliver, and he didn't buy it. He said basically, well, they both committed fraud. Okay, so now you're rewarding, so you're saying you're not going to reward my client when they both committed fraud, but now you're rewarding the other party because the fraud now gets her half of my client's nice retirement. So he denied it, so you can't take that up until you finish the case. Well, guess what? Next issue came up. When does the marriage start? Does it start when they had the ceremonial wedding? Does it start when they got married in Massachusetts? When does the marriage start? So of course the other side's arguing that. I don't want to go back any further than Massachusetts, so we have that fight. Then we have a third fight. In 2012, when they separated, they both believed it wasn't a legal marriage because of Ohio, so they did a financial settlement agreement. They did a separation agreement. They divided everything. They did no retirement because there was no mechanism to transfer retirement. No quadros could go on. No way could that retirement get paid out until retirement age. So they left that out. But it was a very detailed agreement. They did it themselves. It was a very detailed agreement. So the unmoneyed spouse, we'll call her, wanted to argue, well, I was told I couldn't get any more than this because it wasn't a legal marriage, so you should set that aside because I was misled. I was misled, but that was the law at the time. So we have all these issues. Isn't this a great law school question? We have all these issues. So we start our trial. We start our trial, and the heat went out in the building. And it's winter. And I got my coat on, my gloves on. I mean, it is cold. And Judge Oliver says, we're going till 6:30 tonight.
Good.
Yeah, it was great. So we had a whole full day of trial. We go to lunchtime on the second day, and the judge says, I want to see counsel. So we go back, and he says, okay, you two, you're going to have to settle this case. And I said, okay, why? He goes, because either Cathy, you're going to win, and I'm going to recognize the 2006 marriage and the financial agreement of 2012. Or Mike, you're going to win, and I'm going to go back to 2000 and all the way up to the filing of the divorce. Now, you both have a lot to lose. Go out there and settle this case. We did. For myself, I'm disappointed because I think those were great issues to be taken up and see where they would come out. But for my client, that was the best benefit. So, very interesting set of facts that takes up all these issues. So what questions does everybody have?
There was the case, the Texas Supreme Court case from earlier this year, where they had originally, it had to do with whether your spouse could get or some kind of retirement benefit if you were a city employee in Houston.
Okay.
And I don't know if you've heard of this case or not, but originally the Supreme Court in Texas had denied to hear it, and then after political pressure from Governor Abbott and the Attorney General, they decided to hear it anyway, and then ruled, I think, like 4-3 that City Houston didn't have to provide this benefit. And so I guess since you haven't heard of it, then this question's relevant. But I was wondering if you...
Well, wait a minute. Give me the facts of, were they married? Legally married?
Legally married, yeah.
Same-sex couple legally married.
And the Supreme Court text basically, I think, for political reasons said, they don't have to extend that benefit. And it seems to go directly counter what Obergefell said about
I think it is.
And so I was wondering if you had heard anything procedurally, if that was getting appealed to the U.S. Supreme Court.
I have not heard about that, but my take on it would be that the U.S. Supreme Court will say you're wrong. Yeah. Once we, when you find something unconstitutional, it's unconstitutional forever. Mm-hmm. So that's why marriages that happened in Massachusetts have to be recognized in Ohio.
Yeah.
And California have to be recognized in Ohio, even if they're pre-Obergefell.
Yeah, it just seemed to me like, especially now that Roberts joined the majority in the second case, the one from this year, it seems to me that it would be, this Texas Supreme Court thing would be summarily reversed probably, just like Van was. But I didn't know if the parties were pursuing that or if they had filed cert or I
Yeah.
didn't know, maybe.
I haven't heard about that. I'll look into that. I haven't heard about that.
Yeah, I don't remember the parties' names, but if you Google Texas Supreme Court
Sure.
gay marriage, I'm sure it'll pop right up.
Yeah, yeah. Okay. Well, let me, I have a few other things that I can add to this. I knew this wouldn't take the full hour. I was hoping you guys asked more questions.
Are quadros a problem?
No, no. The quadro was a problem in my case because when they split, there was no legal marriage recognized in Ohio. Now, if they'd moved back to Massachusetts and done it there, maybe. Although I think Massachusetts somebody might have raised the fraud issue there. No, not once you're legally married. And now we have to recognize those marriages, so there wouldn't be a problem. But if they were just strangers, legally, there couldn't be a quadro.
If one party has children from before,
Mm-hmm.
not the other ones,
Mm-hmm.
do you need to put those names on a complaint?
No. No. They're not part of the case. They might be part of the case for child support calculation when you get into other children that you get credit for that are in your household.
Well, okay.
Like post-divorce where you got a new family and you got kids that you get credit for them on the worksheet. The tax exemption would be big credit. Okay. One of the things that possibly could have happened in Mullen, the bad fact case, that I would have suggested was that so she won't agree to a shared custody. Can you do some other kind of agreement that says, if we separate, just like you would on a house, if we separate, I still want you to be involved with the child, I still want you, at least she would have had something to hang her hat on, while they were in good shape with each other. I want you to have rights, I want you to have parenting time, companionship time, I want you to have right to get school information. If they'd written all that out, remember this wasn't a marriage, if they'd written all that out, maybe the other one would have had something to hang her hat on, and somebody who wasn't acting so crazy probably would have had something to hang her hat on. So I'm just suggesting these are all things, if somebody comes to you and says, my partner won't do a second parent adoption, they won't give me shared custody. If you still want to stay with that person under those circumstances, that's your business, but maybe you could write something else out that's lesser, that's an agreement.
Where do you file that?
You wouldn't, but it'd give you something to hang your hat on when they're not angry. I'm just, trying to give people some basis.
When you say that the Colorado, Hawaii, Illinois, New Jersey civil unions are still offered, is that instead of the marriage?
Yes.
Do you think that will hold up in the long run if that's challenged?
I think they'll get rid of it. But I don't know why they did it. I didn't look into why they kept it or why they still have
Something
them.
in form of or substance, if the substance is the equivalent, a rose by near the name smells of sweet.
I agree. I don't know if they did it to appease, the people you're talking about, or if they did it because not everybody wants to get married.
Is the civil union in those states open to heterosexual couples as well?
Oh, yeah.
Yeah. 'Cause I've heard it, I think it was there's some European country, maybe Switzerland or Sweden, I can't think of which, but essentially they had, for heterosexual couples, had several different levels of marriage, if you will, where here's level 1, and you have these benefits, level 2, level,
Interesting.
depending on how serious you wanted to get about it, I guess. And it's for that reason, is some couples just didn't want to jump all the way in, but they wanted some kind of partnership benefit, I guess.
That's interesting. I've
I don't
never
know
heard
if
that.
that's still true post,
Right.
I remember hearing that maybe 3 or 4 years ago.
Mm-hmm.
I don't know.
Interesting.
I have a question.
Mm-hmm.
Now that they've established the legality of same-sex marriages, is that the starting point of a same-sex marriage when they go and get married? Or do you establish it if they had it prior to that?
Well, that's my point. That's what we were talking about. When does the court look at the duration of the marriage? I think it's possible the court goes all the way back to when they held themselves out as a couple if they had a ceremony. I think the court,
File a complaint, you have no idea what to put in there.
it depends on which side you're on, doesn't it? As my father used to say, it depends on whose ox is gored. So yes, if you're on the side that wants a shorter marriage, you argue it's the date of the actual marriage. If you're on the side that wants to expand that for property reasons, you argue it's the whole time. And I'm already on record with a bunch of lawyers saying I think you go all the way back, so
I think that's the equitable thing. But
yeah.
I know the relationship, I think it's equitable.
So it'll bite me if it ever happens to me. Hopefully
How
not.
did you have to complain on that?
No, I think you say the legal date of the marriage, and then you put in there, you have to add. You don't say that's the legal date of the marriage. It's not. You put the legal date of the marriage, and then you put, but the equitable date of the marriage is.
I see.
Can I ask one?
Mm-hmm.
When we had common law marriage, basically is an agreement of present time, plus holding yourself out as being married.
Right.
But we got rid of that.
Mm-hmm.
Now, if you then come up with the argument going back, and that was a time when Ohio no longer had common law marriage, don't you have a problem there?
The 9th District completely agrees with you. The 9th District said you are recreating common law marriage, which doesn't exist. So that's the argument, that it's not right. And then the other argument is, this is a court of equity. The court of equity doesn't have to recognize the marriage, but can recognize the equitable division of property. That's the other argument.
So, I don't know that this fact pattern exists in reality. Well, I think it could, potentially, but I don't know that anyone's ever brought it up. But like, let's say you were in a same-sex relationship that, had it been a heterosexual relationship prior to 1991, would have been a common law marriage.
Yes.
And then you break up, let's say in 2018, how would the court treat that
It's a common law marriage.
as a common law marriage?
Yes,
So,
and you have to get divorced.
So the court wouldn't say, well, back then there was no such thing as a homosexual common law marriage, so we're not going to recognize it.
No, I don't think they can. I don't think they can because of Obergefell. Obergefell said it's unconstitutional. So if we're going to recognize a heterosexual common law marriage from that pre-time, you have to recognize a same-sex common law marriage from that pre-time. I hate to tell you that most of those people are dying.
Well,
Because I know a lot of them.
I have family friends from back home that have been together since like the 70s, and they're not going to, and one of them is pretty ill, but they're not going to be breaking up anytime soon.
I know.
What if,
Yeah.
for some reason,
And I think they'd be smart for probate purposes, for estate planning purposes, they'd be smart to get married.
well,
I think.
I think one of them is a school teacher at a private school.
Yeah, I hear you.
It's hard to,
Yeah, I was a year too late for common law marriage, so.
When you say get a will.
Yeah, get a
trust.
will. Yep,
Don't leave it up
absolutely.
to the law.
You do not want to be fighting that common law marriage fight in probate court. So they could sneak off and do it quietly. I think I talked about that. Let's see if I can add anything to this. If any of you are curious about that case I found in Ohio about it was a niece and an uncle, I take it back. It was a niece and an uncle. It's called, I'm going to spell it, Basickas. 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 93 Ohio App 531. It tells you how old it is. And then there was one that was approved in 1979. That case was from the 50s. In re Estate of Stiles. And that is 59 Ohio State 2nd 73. That was all about fraud. So it's something that could come up again, potentially, if you have people that did what the McKettricks did in Massachusetts. All right. Any other questions? I want to make sure you get your full credit here. Um, I'll tell you one other interesting thing about Hamilton County. We're such a dichotomy. We recognized shared custody agreements, and we also, our domestic relations court has never had a problem with a parent who's gay. They've just never had it. I have had cases where I've gone in and the other side's tried to jump up and down and say, well, they're getting divorced because this person's finally come out and the kid shouldn't be around him. And the court goes, okay, tell me what they've done to harm the kids, mentally, physically. Well, nothing, but they're gay. So what? I've never had a problem with our court about that, which is nice.
What about polyamorous relationships?
I've never had that happen in a divorce case, but that could be a bigger issue, I would think. But never had to deal with that. So, any other questions? Okay, thank you.